Your Honor, this case presents a fundamental question about the nature of copyright protection. Whether works generated by artificial intelligence without human authorship can qualify for copyright registration under United States law. The answer is clear: they cannot. Mr. Thaler seeks copyright protection for a visual artwork that he openly admits was created entirely by his AI system, Opus, with no human creative input. In his own application, he listed the artificial intelligence system as the sole author. This admission is fatal to his claim. Copyright law has, since its inception, required human authorship. The Supreme Court established this principle definitively in Burrough-Giles v. Sereny, recognizing that copyright protects works that originate from human intellectual effort and creativity. The court emphasized that copyright exists to incentivize human creation and innovation. Your Honor, the Copyright Office correctly denied Mr. Thaler's application because our constitutional and statutory framework simply does not contemplate non-human authors. When Congress enacted copyright legislation, it did so with the understanding that authors are human beings capable of owning property, entering contracts, and being incentivized by economic rights. To extend copyright protection to AI-generated works would fundamentally undermine the constitutional purpose of copyright, to promote human creativity and learning. It would create an unprecedented expansion of copyright scope without legislative authorization. The evidence will show that Mr. Thaler's application fails on its face because he cannot identify a human author. Without human authorship, there can be no copyright. The Copyright Office's denial was not only correct, it was compelled by law. Thank you, Your Honor.
Your Honor, my learned friend's argument rests on a fundamental misreading of both the statutory text and the constitutional framework governing copyright law. The Copyright Act does not explicitly require human authorship. Nowhere in the statute does Congress state that only humans can be authors. Instead, the Act speaks in functional terms about original works of authorship, fixed in a tangible medium of expression. The question before this court is whether Davis's creation meets these statutory requirements, and it clearly does. Your Honor, the plaintiff's reliance on Burrough-Giles is misplaced. That 19th century decision addressed photography technology that was then revolutionary. The court there embraced technological advancement in creative expression, rather than rejecting it. Just as photography was once deemed too mechanical for copyright protection, we now face the same unfounded skepticism toward AI creativity. The evidence will demonstrate that Dobes produced an undeniably original visual work, one that exhibits creativity, artistic merit, and the spark of authorship that copyright exists to protect. The fact that this creativity emerged from artificial intelligence rather than a human mind does not diminish its constitutional worthiness. Indeed, Your Honor, granting copyright protection to AI-generated works serves the constitutional purpose of promoting progress in the useful arts. It encourages innovation in AI technology and ensures that creative works, regardless of their origin, receive appropriate protection. Mr. Thaler's application should not fail merely because he was honest about his AI system's role. The law must evolve with technology, just as it did for photography, sound recordings, and computer programs. The Copyright Office's rigid interpretation stifles innovation and ignores the clear statutory language. We respectfully urge this court to recognize that creativity deserves protection wherever it originates. Thank you, Your Honor.
Your Honor, my learned colleague's argument demonstrates precisely why Mr. Thaler's application must fail. The defendant asks this court to rewrite fundamental copyright principles based on a strained reading of statutory silence. First, regarding statutory interpretation, while the Copyright Act may not use the word human, the entire statutory framework presupposes human authorship. The Act refers to authors who can transfer rights, receive notices, and make decisions about their works. It contemplates authors who have legal capacity, something only humans possess. An AI system cannot own property. cannot enter contracts, and cannot exercise the exclusive rights that copyright provides. Second, the defendant's reliance on Burrough-Giles actually supports our position. That case involved a human photographer making creative decisions about pose, lighting, and expression. The Supreme Court explicitly noted that the photograph resulted from mental conception and was produced by and under the direction of the photographer. Here, Mr. Thaler admits he provided no creative input. The work emerged entirely from Dabus without human direction or conception. Your Honor, the constitutional purpose of copyright is to incentivize human creativity. Article I, Section 8, grants Congress power to promote progress by securing exclusive rights to authors. The framers used this term with the understanding that authors are human beings capable of being incentivized by economic reward. An AI system cannot be motivated by copyright protection. Moreover, granting copyright to AI-generated works would flood the registration system with computer-generated content, potentially drowning out human creativity, the very opposite of the constitutional purpose. The defendant cannot escape this fundamental flaw. Without a human author, there is no constitutional basis for copyright protection. Thank you, Your Honor.
Your Honor, the plaintiff's arguments reveal the very legal rigidity that this court should reject in favor of a forward-looking interpretation of copyright law. First, regarding statutory structure, my learned friend's argument about legal capacity fundamentally misunderstands copyright ownership versus authorship. The Copyright Act distinguishes between these concepts. While Mr. Thaler, as a human, can own and exercise the copyright, Dabus can be recognized as the author. We see this distinction throughout copyright law. Works made for hire, where corporate entities hold rights, but individual humans are often the actual creators. Second, the plaintiff's reading of Burrough-Giles proves our point entirely. That decision embraced new technology rather than rejecting it. The court there could have easily held that mechanical reproduction was incompatible with copyright, but instead recognized that originality and creativity can emerge through technological means. Your Honor, we stand at the same crossroads today with artificial intelligence. Third, on constitutional purpose, protecting AI-generated works absolutely serves the progress of useful arts. It incentivizes innovation in AI technology itself, encouraging humans like Mr. Thaler to develop systems capable of creative output. The constitutional framework rewards human ingenuity in creating tools that expand creative possibilities. Your Honor, the plaintiff's flooding argument is particularly troubling. This court should not deny copyright protection based on speculative administrative concerns. Each work must be evaluated on its own merits for originality and creativity, criteria that Dabus's artwork clearly satisfies. The evidence will show that Dabus created an original, creative work that advances artistic expression. The law must evolve to recognize creativity wherever it originates, just as it did for photography over a century ago. Thank you, Your Honor.
Your Honor, this case ultimately turns on a simple but fundamental principle. Copyright law protects human creativity, not machine output. Throughout this proceeding, the defendant has asked this court to abandon over 2 centuries of copyright doctrine based on speculative arguments about technological progress. But the law is clear, and Mr. Thaler's own admissions are fatal to his claim. The evidence shows that Mr. Thaler explicitly listed Dabus, an artificial intelligence system, as the sole author of the work in question. He provided no human creative input, made no artistic choices, and exercised no creative direction. This is not a case of human creativity aided by technology. It is a case of pure machine generation. Your Honor, the defendant's attempts to distinguish authorship from ownership cannot overcome the fundamental constitutional barrier. Article I, Section 8 empowers Congress to secure exclusive rights to authors, a term the framers understood to mean human beings capable of being incentivized by economic reward. The entire statutory framework confirms this understanding through provisions requiring legal capacity that only humans possess. The defendant's reliance on technological evolution misses the crucial distinction. Photography in Burrough-Giles involved human creative decisions about composition, lighting, and subject matter. Computer programs involve human programmers making creative choices. Here, we have pure machine generation without human creative contribution. Granting copyright protection to AI-generated works would not incentivize human creativity. It would substitute machine output for human authorship, undermining the very purpose copyright exists to serve. Your Honor, the Copyright Office correctly applied established law. Mr. Thaler's application must fail because, without human authorship, there can be no copyright. The plaintiff respectfully urges this court to affirm the Copyright Office's decision. Thank you, Your Honor.
Your Honor, we stand today at a pivotal moment in copyright law, not unlike the moment this court faced when photography challenged traditional notions of artistic creation. The plaintiff asks you to reject Mr. Thaler's application based on an outdated interpretation that would have denied copyrights to every technological advancement in creative expression. Their argument rests on a false premise that copyright law explicitly requires human authorship when no such requirement appears in the statutory text. Your Honor, the evidence is clear. Opus created an original, creative visual work that satisfies every statutory requirement for copyright protection. The work exhibits originality, creativity, and artistic merit. It is fixed in a tangible medium. These are the functional requirements Congress established, not species-specific limitations that the plaintiff now asks you to read into the law. The plaintiff's constitutional argument fails on its own terms. The framers sought to promote progress in the useful arts. Protecting AI-generated works does precisely that. It incentivizes human innovation in artificial intelligence technology and ensures that creative expression receives protection regardless of its technological origin. My learned friend's distinction between human-directed technology and pure AI generation misses the fundamental point. Humans like Mr. Thaler developed, programmed, and deployed these AI systems. The creativity may emerge through artificial intelligence, but it stems from profound human ingenuity. Your Honor, the Copyright Office's rigid interpretation would freeze copyright law in the 19th century, denying protection to works that clearly advance artistic expression and technological progress. Just as this court once recognized that mechanical reproduction could produce copyrightable works, so too must it recognize that artificial intelligence can generate original creative expression worthy of protection. We respectfully urge this court to grant Mr. Thaler's application and allow copyright law to embrace the creative future. Thank you, Your Honor.
After careful consideration of the arguments presented by both counsel, this court is prepared to rule on Mr. Thaler's challenge to the Copyright Office's denial of registration for the AI-generated artwork. Orling. Reasoning. Constitutional Foundation. Article I, Section 8 grants Congress power to secure exclusive rights to authors. The plaintiff correctly argues that this term, as understood by the framers, contemplates human beings capable of being incentivized by economic reward. An artificial intelligence system cannot be motivated by the prospect of copyright protection, nor can it exercise the exclusive rights that copyright provides. Statutory framework. The Act contemplates authors who can transfer rights, receive legal notices, and enter into licensing agreements, legal capacities that only natural persons possess. Precedential analysis. The precedent of Burrough-Giles v. Sereny supports the plaintiff's position. While that case involved new photographic technology, it explicitly required human creative contribution, mental conception, and direction by the photographer. Here, Mr. Thaler's own admissions establish that he provided no creative input or artistic direction. This distinguishes the present case from scenarios involving human creativity aided by technological tools. Policy considerations. While encouraging innovation in AI technology may be laudable, it does not overcome the fundamental requirement of human authorship embedded in our constitutional framework. The Copyright Office's denial of registration was legally correct and is hereby *. Court is adjourned.